to thank everybody for joining us again this morning. I think we got a pretty interesting couple of topics here, titled basically Love Letters, Marriage, Divorce, and Death. And I know that sounds like a sexy romance novel or a Netflix miniseries, but it's not. We will try and make it a little bit sexy, and maybe there's even a little bit of drama in here as we go through. But this, like any other of the Zoom conferences we have, it's meant to be interactive. If there is background noise, please mute put your settings on mute. But we're going to discuss a lot of items dealing with the love letters, as everybody's aware of, how to handle people that are either married, engaged, just a couple that wants to live together. It's going to be telling you to ask a lot of questions. We are not attorneys, and we all know that. So we don't want you acting like attorneys. But what we do want you to do is encourage you to, whenever you're involved in any of these kind of transactions, there are a lot of questions to ask. This class was presented to me a couple weeks ago, or more like about a month ago, with the Pennsylvania Association of Realtors. They put on a lot of really good classes, and Tammy Andrews and I were just talking. It's wherever I'm licensed, I tend to join both the state and the local boards. I think it's important that we do that when we're multi-licensed, because you get a lot of information and a lot of education, and we owe it to our clients to be the best that we are or can be, to have the education and the knowledge to assist them. And I find that Pennsylvania, out of all the boards that I belong to, feeds me the most information of any of them that I participate with. Every day I get a newsletter from the Pennsylvania Association of Realtors with something educational in it, and it deals with all different aspects. I just sent one out today to all the Carroll County agents and the Fulton agents, and it just deals with, competitive contracts, the cash, how it's the winner, but it also talks about the percentages of each contract, how many are giving up inspections, the percentages, how many are paying cash and things of that nature. And it's just, it's good information to have. Okay. So let's go ahead and get started. And Sean and I both will be sharing in this as we go through it, but I'll start everything off. And of course, the biggest thing that we hear a lot of over the past year is the love letters. And those are the letters that your clients tend to feel inclined to want to be part of the contract, or even agents want it to be part of the contract, to show something to where your buyer is different and to unique, and sort of to encourage the seller to accept your offer. The problem we run into with some of these things is they can be interpreted in many cases as being in some way a violation of fair housing. And I can give you an example. For instance, if the buyer mentions how their children would enjoy having Christmas in the home, or how the church is nearby, you got religion being pulled in it. It can be interpreted as if the seller accepts that contract, was it based off the fact that these are religious people, or they're Catholic, they're Jewish, whatever it might be. Pictures being part of the love letter can create issues. Are you selecting them because of their ethnicity and their race, whatever it might be? These are the issues that we run into. Now, Joe Driver sent something out about a week ago that in the state of Oregon, that a district judge handed down a decision that says that he felt that National Association of Realtors saying not to be able to send these out, and you shouldn't send them out, is a violation of freedom of speech. But they also acknowledge in the same breath that we realize that when you do this, you could be violating fair housing. Now, National Association of Realtors has not changed their position on it yet, or may never. But this is just to let you know, if you hear the rumor that a district court judge in Oregon handed down this decision, they did indeed. And Sean, do you have any comments?
Well, we know I always have opinions, so thanks.
Yeah.
Thanks for that great intro, George. And I loved what you mentioned in the beginning about, if you are going to be multi-licensed, the importance of being involved, at least tangentially, if not, big time in the board tangentially so that you get those types of information. Because you're right, you share those PA things with me and they really do put a good amount out. So that was a great point out there. George and I were talking about this yesterday with these love letters, and the judge in Oregon, as George said, felt that it was infringing on freedom of speech to say that you cannot. And I get that point. George and I were discussing this yesterday. I get that point for the general public, but the impact on us as licensees, because we are bound by the code of ethics, and we know that the likelihood of somebody coming after somebody who feels aggrieved is going to be one of the easiest targets, can be one of us, because that's free. And they can, you know, in no bad intention, using those letters really can set you up for, never mind the parties, the civilians in the transaction. It's us who hold licenses, who we held to the higher standard. And that's where we can get into trouble with fair housing.
And one of the other points that the attorneys made when they were discussing this, they said, if a seller does accept based off of a love letter, not only is the seller potentially violating fair housing by choosing an offer based off the love letter, but if the agent is facilitating the that love letter, fair housing violation, it can quickly be a violation against the agent as well, because they facilitated it. So they pointed out a lot of good things. And let's see, a seller selects a buyer A. In the example, there was an example they gave. One of the love letters is introduced. A seller is now making a decision with subjective criteria that could override objectivity of other offers. In other words, they're accepting this offer based off the love letter because they get emotionally about the client or the buyer that's making the offer, but they neglect to look at the other issues within the contract. You know, one may be they can settle faster, or they're maybe they're declining to do a home inspection, or whatever it might be, but they accepted this other offer strictly because of the love letter. They might find that they run into other issues with the contract itself, and that's one of the other things that they pointed out as well. Anybody have any remarks or comments about the love letters? This part of it was probably kind of short for us.
Yeah, I mean, it's kind of sad if you think about it. We've all been involved with clients that we get close to, and they simply want to express their love for this house, the feelings that it brings up for them, and seeing themselves in the house. So on a human level, I'm not always just about the law and what can happen to you. On a human level, it is kind of sad. And I see the judge's point in Oregon, even beyond free speech. It's there used to be, for those old timers of us that have been in business a long time, there was an element of personality in it. But the more that we go into that realm of personal decisions and we get involved in them, the more likely it is that we could get called to the mat for it.
And another thing that they pointed out, oh, I'm sorry, go ahead.
Yeah, Sean, I don't know if am I muted or can you hear me?
We can hear you.
Okay. Escalation clauses were a thing that came out of Montgomery County. Nobody wants to use them anymore, although they still try to do it. The love letters were another little trick, which I think all of that stuff, you know, I agree, we have to kind of look the other way on that and not use it, because we could get ourselves in trouble. What the judge said, if they want to send something to the seller after the fact to their address and leave us out of it, that would probably be the better way.
Well, and I'll talk a little bit about that in a second. But most of what we've been discussing here is the effects that can be had against the seller and the agent. But also keep in mind too, now that a buyer or a couple has submitted a love letter, and if they get rejected, they sort of take it more personal now. They feel like maybe you did not accept their offer because of something they put in the love letter that could be in some way a violation of fair housing. That becomes a whole different situation now. And the other thing that the attorneys were real strong about is, or encouraging everybody, they said, as far as a listing agent and a buyer's agent, they strongly recommend that you have a conversation with them about love letters and let them know that you know that it's something that people do. And you explain to them the reasons why we do not or do not want to do that. But one of the things that they said, which again, every state's a little different, but they said, whatever decision the seller or buyer makes, you're still supposed to follow that. I'm not so sure I go along with that, because they're saying here at one point that if the seller ultimately still instructs you, or the buyer rather, still instructs you to send a love letter, they're telling you should. Or if the seller says, I still want to see it, they're telling you that you should present it. I don't know, because I don't know how that stops us from being in violation of fair housing if a dispute comes up regarding that. Sean, your 2 cents?
Yeah, I find it more effective these days to just bring a bag of cash and a new car for the seller, because nobody wants these love letters anymore.
Go ahead, Gina.
So I took a class last week and an agent mentioned her workaround the situation was that the law didn't say that she, as the agent, couldn't send a quasi love letter directly to the other agent. What are your thoughts on that?
Keep in mind, it's not a law. There's no law saying you can't send it.
Right.
Okay, there's no law that says you can't. What it is that the feeling of a violation of fair housing, it's the content of the letter is that what we're really concerned about. What's written in there. If they make reference, even if they make reference to children, they make reference to a church, being close to a church or a synagogue or whatever it might be, and the other person loses out, or can they file a complaint and say you accept it based off of that information? And then is that in itself a violation of fair housing? That's the issue. It's not that you're violating the law by sending the letter itself. It's the content of the letter that may be violating fair housing is what we're concerned about.
So,
All right, we have
go ahead.
a question. We have a question whenever you guys get.
Go ahead.
Okay. The question is there a something that RE/MAX Advantage says they want us to do? Is there a standard with our company? Could you hear her?
Somewhat.
Were you asking if there's a standard for what we do as a brokerage?
Yes.
Okay.
Yeah, it's not like it's in our policy and procedures, because this is a fairly new phenomenon in saying it's not a good idea. Again, bag of cash and new car seems to be the better idea, but I'll go back to like what Gina said. I find it probably a bigger potential problem for the agent who writes that letter herself than just handing the one off that was like, oh, whoops, did that get in my paperwork? So I would say that as a company, we strongly encourage our clients not to give or receive those love letters, just based on NAR and MAR's directive that we, with all good intentions, and we're all people, we all want to still work on a personal level. With all good intentions, it only takes, like George said, it can be the person who didn't get the property, or it's fraught with possibilities of getting yourself into a pickle. So we really are not condoning it. Yes, ma'am.
So as a listing agent, are we supposed to disregard if we receive one?
We
Not
should.
even- Not even mention it to the seller?
We should not.
You're hearing them a little bit better than I am, Sean.
Well, the problem I see with that is that has happened to me. And the seller actually got the letter because they put it in their mailbox.
So they went around you.
And they wanted to know if I received it, and I told them yes. But because of the situation, I decided not to disclose it to them. So it has been, they would have appreciated me telling them, so.
And can that just all, if we have our listing appointment and just discuss up front with the seller, here's the situation. Are you in agreement that if any come in, I don't give them to you, and maybe knock that issue out in the very beginning?
And that's exactly, Gina, what the attorneys were recommending. Whether it's a buyer or a seller that you're working with, you discuss this prior to them either making or receiving any offers. You let them know the issues that accompany receiving a love letter or sending a love letter. You let them know up front. It's like anything else we do. We talk to our buyers and sellers. We teach them about the real estate transaction. I always use the term that we don't sell real estate. We educate people in the real estate transaction. And that's what our job is. And that's what we should be doing. Any buyer that you work with, I know all of you do it, you work with these buyers, and before you really submit any offers, or maybe even before you even go out and show them homes, you're educating them in the process. I do an interview that I do with every buyer before I take them out. Now, I'm not saying that there aren't exceptions, but I sit down with them at a minimum of an hour to an hour and a half, and I go over everything from, nuts to bolts. And they won't remember it all, but as you go through it, they'll start remembering as you remind them. And I do talk about the love letters. The same thing with sellers. I talk about it. Now, I could take it a step further, and I haven't. I could create part of the listing agreement that I create an addendum that indicates that I've reviewed it with them and they have chosen not to accept them, and so forth, whatever it might be. But, that may be pushing it a little bit. Any other thoughts?
I've seen in agent remarks in Bright, do not send an escalation and do not send a love letter.
Yes.
It will not be presented to the sellers.
I've seen the ones for the escalation clauses, not the love letters.
Yeah, I've seen both.
Good.
Of course, like in Nita's case, then the buyer cleverly ran by and put it in the seller's mailbox. So we
But
keep control
That's
of that.
really cheeky. That's wow.
Yeah, that is. I go, yeah.
Joe, I think you had your hand up at one point, Joe Driver.
The issue isn't writing one, giving one, receiving one. It's the content of the letter and perception of that content based on the party that did not get the contract. And they're not illegal. The problem is it's the perception. So the perception is, oh, I lost this house for a reason. And when it comes to fair housing, now you're in federal court. And Sean, can you give me how much the attorneys charge per hour to defend us in federal court?
Never had to go to federal court.
Okay, fair housing is federal. Share a number with your sellers. Okay, if you're willing to split this cost with us, because perception is reality. Again, everybody's correct. They're not illegal. It's the content of the letter and perception from the party that did not get the sale. So just from an economic standpoint, I would explain that to the sellers that if we wind up in federal, this will not end well for anyone. Forget the fact you don't want to see Judge Judy on a local level. I wouldn't want to see Judge Judy on a federal level. Nothing good is going to happen in that conversation. Take your checkbook, sign it, and she'll be more than happy to fill in that dollar amount for you.
Okay.
That's my story. I'm sticking with it.
Here we go. Okay.
Good
Any more
time.
questions, or we'll move right on to marriage? That might even be more fun.
Okay.
Okay.
You don't do that. Don't, the biggest cause of divorce is marriage. Don't do it.
This is true. Statistics show that, don't they? When we're talking about marriage and unmarried people, the statistics from National Association of Realtors indicate that 60% of buyers are married. 19% are single females, 9% are single males, and 9% are unmarried couples. So when I talk about marriage, I'm talking about relationships, really, is what we're going to discuss. So the important thing is when you're talking to buyers, and let's say it's an unmarried couple, you need to understand who's going to be holding the deed, who's going to be recorded on the deed, how it's going to be recorded, the type of tenancy that they
You're not
take.
on camera, by the way. It's just, I'm blacked out.
I just heard somebody say something. Okay, the type of tenancy that will be held. Who's coming up with most of the money? And these are questions you need to know and understand. It's you also run into situations where somebody buys a house when they're single and then later get married, and what happens there. Sean, you want to touch on any of that kind of information?
I think we've all had these where you, and this is one of the, like sometimes to know the reason behind the ask on our checklist of forms, asking for a copy of the deed. This is one of those times and reasons why we ask for it. We ask for it a lot of times because there might be a missing child or relative that even the sellers may have forgotten tangentially that was added to the deed, or took some ownership at the death of somebody else. So why we ask for a copy of the deed, which I know is a pain to go get it, but it puts you on level ground to know who you're dealing with as the seller and how they're entitled and who they're entitled with. So for instance, if you have, and I'm going to a little bit go into it, but this is one of those things where when they make these life decisions, they'll want to talk with their accountant or an estate attorney. But we'll see people create trusts, revocable and non-revocable. We'll see people add children to the deed, grown children, hopefully not children, grown children to a deed, and maintain a life estate for themselves so that it passes directly to those children or child at the time of their death. So getting a copy of the deed in today, as it sits on Maryland land records, is so beneficial because you start from point A knowing who you should be having sign your paperwork. So if you have, for instance, and I'll just touch on this, if you have somebody who buys a house together, you have a young couple, they go out and they buy the house and they're going to get married in a few months. So they buy before they get married, and they probably took tenancy as joint tenants, so they would have survivorship. Then they get married. They don't automatically go to tenants by entirety because they get married. And just as part of your conversation with them, maybe remind them that after they get married, for their benefit, they may want to go back to whichever title company did the settlement for them and change their tenancy, because that tenancy protects them from individual judgments and liens. So that is just a helpful tip to tell your young clients who are not yet married when they purchase. After the honeymoon, after things settle down, get back to your title company for a very small fee. They'll be able to make this change for you. Just good piece of information. On the contrary, and we're in marriage now, but I guess to the contrary, one thing to remember too is when you are married and you have title together, and if you are taking a listing and this is a contentious divorce and they can't wait to get apart from each other and they're going to get this divorce and they want to sell the house. In today's market, the house sells so fast, they won't even be done arguing, let alone divorced, by the time you get to settlement. So, but if you have a married couple entitled together, and they're contemplating divorce, it would, and again, they should talk to their divorce attorneys, but it would behoove them, especially in the case where maybe part of the reason for the divorce is financial difficulty brought on perhaps by one of the partners versus the other. Because as soon as that divorce happens, that tenancy by entirety gets broken. And then any judgment or lien that got filed against one but not both will now attach to the house. And if they were already upset with each other and now their proceeds get tacked by these judgments or liens, that's not going to end well either. So just as you're taking these listings where people are in flux, good or bad, whichever direction they're aiming, just maybe tangentially giving them little pointers and advising them to talk to their attorneys if they're going through a divorce, or if it's a happy time, just get back to their title company if they choose to take title. And anybody who's married who would not take title as tenants by entirety, I'm not sure why. Unless it was like a second marriage and they had grown children and they want their children to get their side if something happens to one of them. So that's counseling brought better on by the title company than us in any depth, but just keeping tangentially in mind that those kind of life changes can have big impacts on their ownership and the liens and judgments that can get placed against their property.
Yeah, and Sean brought up a couple of good points, and one, I've ran into a couple of experiences myself, as I'm sure many of you have. There was a house I sold back in, I want to say it was 2016 in Catonsville, and it was owned by a revocable trust. The big issue was that the house was in Catonsville, Maryland, and the revocable trust was created in Florida. So now you technically have an out-of-state entity that owned the home, and the capital gains tax was significantly different because it's an out-of-state entity that owned the home. I'm not a tax accountant. All I can do is ask the information about that and tell them what could possibly occur. So they sought the advice of an accountant and found out ways of trying to reduce some of the taxable income. So that's an issue. And again, you find these things out by either one, checking the deed, as Sean's saying, and asking questions. Another issue that came up that would have been caught had I checked the deed properly back in about 2007, 2008, I sold another property in Catonsville where I put it up on a listing. I did not check the deed, and I usually had a company do it for me. There was a title company I worked with that was doing this for me. This one particular listing, I did not. And it turned out that the house, which technically it and the garage sat on 4 lots that were purchased several years ago. The original owner was a single man. He then got married, died. The wife is left there. Come to find out, 2 of the lots were never recorded on the deed by the title company. And that meant the garage and a portion of the house were sitting on lots that were never recorded in the owner's name, the current owner's name. When I went to the attorney who met me on a Sunday, sort of chuckled and laughed and said, "You've got an issue. And not only do you have an issue, the title company that handled this is no longer in business. And the title officer, the attorney that owned the title company, is in prison." So we have multiple issues. So it's important that you do check the deeds. Okay?
I have a question. We have a question here. Hold on.
Go for it.
So as far as divorces, if the sellers get divorced before it settles, but they have both their names on the deed, does that make a difference?
Yes.
Go ahead, Sean.
The minute that the divorce becomes final, it severs their tenancy by entireties. And tenancy by entireties, one of the protections of that is, let's say you have a partner, a husband, and you're entitled together. And the only thing that will break through that barrier is tax liens, like federal or state tax liens. You're not getting away from that. But let's say that you have a husband and you're entitled on this deed together. And one of the reasons for the divorce is that husband got himself in over his head with some debt. He's got judgments and liens that have been placed now through the court system against him. So long as he's married, so long as those 2 people are still married as tenants by entireties, those judgments and liens will not attach to the house. They still stick with him. But the minute that divorce happens, boom, it's like a fissure rips open in the title, and all of those judgments and liens against either or both parties now flood into the picture, and they have to pay them off to sell the property.
But as far as the husband being able to try to get the wife nothing for that reason, because they're divorced before it goes to settlement, if both names are on the deed, they still are entitled to half and half, right?
Correct. Mostly what you'll see is a title company, especially in the case of a divorce or where there's a debate over funds, they'll have a form that says, here's what we both agree to, if it's a percentage, And if they cannot come up, I mean, I'll tell you what I did when I had a title company. If you had a situation like that where they were so bitter and arguing, I would issue one check and say, go out in the parking lot and rip it in half, do whatever you want to do. I'm not going to give, unless there's a court order. If there's a court order saying that through this divorce or through this separation, because it hopefully wouldn't have been a divorce yet, so-and-so is entitled to this and to this. But the title company wisely is going to have the parties sign off on anything other than one check being given or a 50-50 split.
And understand, when you're dealing with people that are going through or have that are separated, going through divorce, whatever it might be, that in itself can be a headache, and you got to decide whether or not that's something you want to handle. I mean, I know there's a multitude of us that probably out there that have been through a divorce and know that the anger and so forth between the parties that's involved, and you're dealing with that. Sometimes it's a challenge just getting both parties. They haven't divorced yet, but they want to sell the home, getting both parties to sign the document. It's a challenge to get them to agree to the terms, because out of anger, one of the two parties doesn't want to accept, just in spite. You run into all these issues. You get the settlement. You could have a full outbreak of a fight. I had one point had to separate the clients and put one in one room and one in another and conduct settlements separately, because the battle that they were going through, the yelling and screaming, it's unbelievable. You've got to be patient with these people. You got to listen to them and understand their frustrations. But in reality, you're representing both of them, and you got to try and bring them together. You will engage the use of the attorneys that are involved quite a bit, okay? Because you're not the attorney. You're just trying to get the transaction done, and you need to make that decision when you're taking that listing. Jay Hall? Thank you, Jay. Okay, so you got to make a decision whether you really want to handle that transaction or not, because it's going to be a headache for you. I can guarantee it. There's very few divorces where you got a husband and wife that are saying, we're friends, we're leaving, we're good, we'll do this together, because sooner or later it breaks into an all-out battle. Okay, we're moving right along here.
Good times, federal court, divorces, liens, judgments.
See, I told you there was a lot of drama in today. There's no sexy scenes or anything like that, but we're doing our best to keep a little drama and excitement into the class.
Or keep it out of our life, right?
Yes. There's even situations. I'm looking through my documents from this class that I took, and they gave another example of a situation in here. Hold on, I'll find it in a second. Here we go. This was a case that they talked about, and they said, consider a recent call to the hotline involving the death of a husband whose son sought to list the father's home, claiming that he was the heir to the father's estate, including the home. At the time of his death, the father was living in the home with his wife, the stepmother of the man claiming to be the heir. The listing agent checked with the recorder of the deeds and determined that title to the property was held by the father and stepmother as tenants by the entireties. The son claimed, however, that by virtue of a prenuptial agreement between his father and stepmother, she did not have ownership interest in the property. And oh, by the way, the son is an attorney. So think about that. The fun that can happen in a transaction like that, and what you're going to deal with. You, again, patience, asking questions, ask a lot of questions of the potential client. Where are they at with all this? Get a good understanding of what you're going to be dealing with. And they recommend don't take a listing where there is an ownership dispute until the matter is resolved, because it's going to be held up. Okay. And I know Sean got into death a little bit as well. And I know many of us have dealt with that. But then again, you need to know who has the authority to sign on behalf of the estate. You need documentation on that. You need to see who has that. There could be a bunch of heirs involved. You know, you could have 6 siblings, 7, 8 siblings that are all listed, but there's got to be one of them, or should be one of them, making the decision. If not, again, another headache. You got one that lives in California, you got one that lives in Maine, one lives in Florida, you got 2 live in Delaware, blah, 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 and it goes on and on and on. How do you get them all to sign? Go ahead, Sean.
Extra pages in dot loop.
Yeah.
Yeah, and then you get into, and we see this sometimes, there'll be, say, 4 siblings that inherited the house through life estate. It's not going to go through probate, or they just simply were left with ownership when the parents passed away. And it's good to know, and I think most of us know, just make a note when you're dealing with that, establish where each of those siblings lives, because anyone who lives outside of the state of Maryland is going to be subject to that, what is it now, 8% Maryland sales tax on their portion of the proceeds. And that is just best to forewarn the parties that the sibling, you know, let's say they're each getting $20,000 from the proceeds out of the sale, the sibling who lives out of state is not going to get that. And that I've seen that get upsetting and sometimes slow settlement down. So if we remember, because then they're all scrambling to figure out too late in the game how they get the person off of the deed who doesn't live in Maryland, you at that point you're in too deep. So it's good to know when you're dealing with something like that, if there are any siblings who maintain residency outside of the state, their proceeds are going to be affected differently because they're not a Maryland state resident. So that's important to know. It's important to know, and I'm just saying the facts. I'm not talking down to anybody or insinuating you don't know, but like a power of attorney that's in place to act on somebody's behalf dies with the person who passes. So if son has power of attorney for mom and you're 3 days from settlement and she passes away, the power of attorney just passed away with her. So that's important to know, because then you're going through getting a personal representative, like George was saying, appointed through the orphans court or through the courts to get a personal representative then appointed. So that will slow things down, because you have to put forth notice, public notice, that the person has passed away and that this person is going to be the PR for the estate, and any debt, anybody that they owed money to then can put a claim to the estate. So that'll typically slow things down a month or 2 if a person passes just before settlement. I've seen that happen too.
And also keep in mind, when you deal with these estates and you have, as I mentioned, 5, 4, 6 heirs that are all part of it, and all of them got to be part of the decision-making process. It can be just like a divorce, where there is animosity towards one another. There could be, disputes that arise, and sometimes to clear these things up can take you a year or longer before you can even move forward with anything. So everything we're talking about today comes down to asking a lot of questions of the potential client, having that conversation with them, getting to know, who owns the house, what are the conditions, somebody passed away, do you have the death certificates, do you have all the appropriate information that you need to move forward? It's just asking a lot of questions.
Mm-hmm.
We're going through this stuff pretty quickly.
We are. Anybody else got any fun topics?
I was just going to say one other thing that deals with when you're dealing with estate sales and both parties have died, that it's a husband and wife died, but the kids are taking control of it. Remember, you also got an issue with the insurance on the home, because now you have a vacant home. And it's going to be up to the heirs or whoever's responsible to notify the insurance company that the home is vacant. And some insurance will change the policy, which gets more expensive because they're insuring a vacant home, which is more susceptible to vandalism, break-ins, things of that nature. So that can change things.
Very good point. You know,
Okay.
it's an interesting segue from that. That's a very good point. When we were going through getting ready to sell my mother-in-law's house, who is still with us, thankfully, but in assisted living, as we prepared the house, because it was vacant, and called her insurance company, oddly enough, they actually said, well, and this will vary, but it was an interesting, you just made me think of this. They said, we will not impose the vacant property, because at that point, it's basically, they're just insuring for fire, not so much vandalism unless you pay a lot of money. They allowed us to keep the homeowner's policy in place so long as we got the house under contract, like within 30 days, because they felt like that activity would constitute not being vacant. But each insurance agent will give you their own answer. But as George said, it's really important to remind the heirs or whoever's handling that vacant property to talk to their insurance agent.
Tammy Andrews had a comment or a question. And you're on mute. There you go.
Yeah, so a lot of people, when they're going through the divorces, some of the spouses may be in title, but they may not be on the mortgage. And when they are applying for home loans as they're splitting up, they assume because they weren't on the mortgage, they qualify as first-time home buyers. So that there's a lot of translation that gets lost in that. And I think that interpretation is really important, that the realtors help them understand if they are in fact eligible as a first-time home buyer. And I believe that goes also with siblings and children that were put on their relatives' deeds, whether they also are eligible as first-time home buyers or not. And that's, you know, savings. And right now, as crazy expensive as everything is, every dollar counts that we can save them.
Great point, Tammy.
And another thing to consider when you're dealing with divorcees or divorcing people that are not through the divorce yet, and a settlement hasn't occurred. One of the buyers, and let's say it's Mary Jane, calls you up and she says, yeah, we're selling our home, but I need to buy another home because I got to get out of here. I've already kicked the bastard to the curb, pardon my French. I've kicked him to the curb already, and I'm moving on, and I got my 401k, and I'm going to use that to help buy my home. Well, guess what? That 401k may be part of the divorce settlement. So be very careful with that, because it was wealth that was obtained during the period of the marriage. You know, retirements and all that all come into play when you're coming up with a settlement of a divorce. So be careful, because that person may not have the right to use those funds yet.
Good point.
I made a couple good points then. Boy, it's my year. Anybody else have any questions?
George,
Yes, ma'am.
that situation that you talked about where the guy was already kicked to the curb, not just the funding, but if somebody goes out and buys something and they're still married, then he owns it too.
Yep.
And they don't think about that. They think,
No.
oh, we're separated or whatever. So they need a special agreement if they're going to do that. And that's not always easy to get either.
No. That's what I'm saying. Some of the biggest battles through these, you know, especially with divorce, is getting both parties to sign the appropriate documents. And if there is in any way, shape, or form something that somebody says, hey, look, she has or he has the power to sign, I don't need to sign, you know, whatever. You want something written from an attorney or something saying that that is the case, that there's been a settlement, or there's been an understanding that only this person has to sign. Whatever. You just want to make sure you have a full understanding, that have all the documents in front of you proving that, showing that.
So, for example, can somebody not be on a loan, but have their name added to the deed?
Yes.
Yes?
I'll let Tammy answer that better. I know the answer too, but Tammy can speak to it better.
Yes, absolutely.
Because, for example, when I got married, I wasn't a citizen yet, so I believe I wasn't allowed to be on the loan, but I was on the deed. If something would have happened to us and get divorced, would I still have gone half?
Yeah, Yeah, if you're entitled and you're on the deed, then absolutely, you're just not liable for the mortgage debt.
That's good. Okay.
Yeah, you're getting a better deal.
That's right. No, finances then, but,
And another good topic while we're here is interpretation of court-ordered and agreements that are on the side. There's a lot of gray area that comes along with that when it comes to the child and housing obligations and liabilities. And there's just so many moving parts that when you're dealing with divorces, it's really good to get counsel from not only your attorney, but have your agents and title and lenders all come together. And I have a client now that I'm helping with this, and there's just so many moving parts that they don't realize when it comes to being able to sell and purchase real estate when you're doing this, whether it be court ordered or, agreements that are not formal.
Yeah, and you have, and you bring that up, Tammy, and I'm glad you did, but there's also something that we ran into maybe about 2 years ago, maybe a year ago. There was a transaction, the divorce had already occurred, but the agreement was that when the wife got to stay in the house, but when she sold it, that the funds will be split between the two. And there was a big dispute over that. And because we didn't have an actual letter from the attorney directing to do that, so the title officer would not write separate checks. She wrote, because both parties still showed on the deed, and that person still wrote the check to both parties. And the other person that was there, the one actually selling the home, got so mad that walked out of the settlement and never took the check, and had it wound up getting mailed, I think, to her or something like that. But it's, again, just asking questions and getting a good understanding of what's supposed to transpire, and being able to have that process in place before you even get to the settlement table. Make sure all parties understand and know what's got to be done. Okay? Everybody's quiet. Now everybody's going to run out and get a divorce. Just to experience it. That's all. Just go through one, just to experience it.
As Sean says, call me.
Well, another
That's-
sensitive piece with the divorces is what comes first, the chicken or the egg, being when does the person that is coming off of the deed, they don't want to take their name off before they know that they're getting their money from the person that's taking over. So I've watched our title offices get really creative, and they feel like divorce attorneys because they're trying to keep both parties calm and comfortable with knowing that they have to follow the rules. The deed has to be signed off on before you can move to the next steps. So if you want to elaborate a little bit on that, that's a real hot button that we're seeing a lot right now. Title would be amazing for this.
Yeah. Are you, Tammy, do you mean like, so, yeah. So if maybe they're divorcing and the wife is going to keep the house and they've decided on the number, she's going to refinance, take some cash out and give it to the husband.
Yes.
And he's looking at the person he trusts least in the world today and signing his ownership rights away and being told you have to wait 3 business days to get these funds.
Yes.
Yeah.
Yes. Yeah. Very, very
Yeah.
sensitive.
And I've been through that too. And my answer used to be, but now I become the person who's responsible. Your beef won't be with your spouse. Your beef will be with me, because I have now taken ownership of getting this deed properly recorded. And in order to do that, to follow the instructions of the whole picture will mean that, and so you're asking them to trust you, the title person, that they have no knowledge of, versus the person they hate most in the world. There's no other, yeah, you're right. There's no way around it. You can't issue those funds for 3 days. So they just, they have to take a faith, or, like hold the wife hostage for 3 days. They could try that until they get their money.
Well,
But
and even when they go to sell their current home, and one of the spouses wants to buy a house and they need the proceeds
Mm,
from the sale of that house, that gets tricky with that timing as well,
Yeah.
because they don't want each other to know their business.
right.
So one or the other starts asking questions. Well, what are they buying? What are they doing? So it's just such a delicate
Yeah.
situation.
Yeah.
Yeah.
You must be talking about Brandy and what was his name? Dave, that you helped me with. I think you became a marriage counselor on that one, and they weren't even married. They came close.
Oh my
but
gosh. Yes,
you took on marriage counselor on that one. Yeah.
I did. I got an A for that one.
Uh-huh. Yep.
Well, you know what they always say is they talk to you guys, all of us, when we're in a training room, and I know the Al Munshauers of the world used to say things like this: we're not attorneys, we're not accountants, we're not psychologists, marriage counselors, but in reality, in many cases, we are. We're a little bit of everything. And in this case, when divorce is probably one of the most challenging ones. You are the level head in the room. You're the one that will stay calm, and it's your goal to keep them calm and keep them back to earth instead of fighting. And I know the title companies get involved in that and do the same thing. But that's part of your job. There are agents out there that specialize in divorce, selling homes of divorced couples. There are agents that specifically state that in their advertising. I'm a divorce specialist, and they're probably all licensed psychologists as well. But I mean, it's a tough job. It's a very, very tough job dealing with it.
Hey, I can't figure out how and why I've been married for 50 years either. So
Yeah.
That's a good thing, Jay. It's a good thing. Trust me.
A lot of us have wondered that, Jay.
yes, thank you. Thank you.
I got a question. What if a PR doesn't contact me that the house is vacant, not knowing that they were supposed to, and that the house has been, he didn't even get it, and I guess the house has been vacant about a year maybe, and now they're dealing with it. What happens if you don't contact the insurance company? I guess that's the major question.
That probably happens more than people realizing to contact. Really, most people, they're dealing with possibly the loss of a parent and wrapping things up. And so probably, I'm guessing more than not, people will not know to do that. I guess it would depend on the insurer, it will depend on the insurer and what the policy reads. And kind of to go back to the interpretation of vacant versus, is there a time period within that particular homeowner's policy? What does vacant mean? If you can establish that, like in the course of my mother-in-law's house, for that month leading up to it, we were in her house more than when she was living there. So vacant is, I would just say it really does depend on whoever holds their homeowner's insurance policy. And if it's still vacant and hasn't settled, they may want to reach out to their insurance company and just say, here's where we are in life. What, if anything, do we need to do? I mean, they can still insure it, but it's going to be it's similar to a policy that is, if you go into default where the lender maintains the right to insure, they want to insure their assets. So it's going to be more of a fire type policy for dramatic loss versus vandalism, or of course any belongings, because there aren't any there. So it would be up to the person who has owned the home, what their policy says.
Okay, thank you.
Thanks, Sean.
And then one more question is, if an estate is created in Maryland for a Maryland house, but the PR is an out-of-state person, are they still subject to the 8% tax?
No, because the proceeds will get paid into the name of the person's estate, and then it has to go into their bank account or an account that the PR has established to close out the estate. So all the assets still get paid in to the person's account that was the estate. Like their name is still tied to it so long as they were a resident. The PR living out of state would not be subject to it because it's the estate will do like a final tax accounting. And if there was any taxes owed, they would pay it that way. But
Okay.
yep, good question.
Going back to the insurance for a second. So is the problem in not reporting it if there were an incident, I'll say, at whether the insurance would cover it if they hadn't reported the change?
Yeah.
Is that where the issue is?
Yeah, that's the potential issue.
Because I have a potential listing right now, and my client, her parents are cleaning the house out. The owner's still living. She went to assisted living, and they're in the process of clearing the house out. And they've told me it's going to take a while before they can even think about listing it. So you're saying I need to let them know that they need to do something about the insurance now.
They may want to talk to, their mom's insurance agent and let them know. And it might be key to, if you're going to give them that piece of advice, that you remind them to tell the agent that there are probably more physical people in that house clearing it out than when mom just lived there by herself. Like that could be an important piece, because vacant doesn't necessarily mean the owner's not there. It means a bad guy walking up and down the street could notice, hey, you know what? Nobody's been there. The grass isn't cut. Like there's more exposure for vandalism or theft in the insurance company's mind versus if people are in and out of there like worker bees trying to clean it up. They may not trigger a vacant house type of situation.
Okay.
Yeah, with vacant homes, a lot of times they become party central for teenagers too. And you'll be amazed at some of the damage that can occur. But the other thing to consider, Jay, turn there. Thank you, Jay. But also, if the house has been vacant for a long time, you got to watch out, because if you're getting into the winter months and they haven't, winterized the home, you could have a busted pipe. And if they haven't notified the insurance company, and all of a sudden you're calling them because the pipes burst, because the heat wasn't turned on, or whatever the case may be. But most people don't know. They're so busy taking care of the estate issues and so forth. Probably insurance on the home is the last thing that they would think about.
Right.
Question.
Dennis?
First, Jay Hall, could you please mute yours?
Done.
Thank you. Secondly, I have a couple going through divorce right now. They have signed the listing agreement and everything is peachy keen, but the concern is that one of the spouses, even after we ratify, there is a lot of malice toward the other. And the concern is that due to whatever you want to call it, malice, revenge, anything else in between, that possibly one of the spouses may pull out or decide, I don't want to sell last minute. How would you, and I guess that's for George and Sean, but everybody else, I guess, in this panel, how would you handle such scenario, and what would you advise as far as ramification, not just to one, but both of them?
Well, I got a couple questions on that. One, if it's just a listing agreement, and I know Sean will correct me if I screw up here, but if it's just a listing agreement, depending on what you have in your agreement as to how soon they can pull out, either one could probably cancel it. And then, yeah, you're right. You don't have an agreement because one of the parties wants out and cancels, because both of them have to agree to it. The issue really comes up is if you're under contract and then somebody changes their mind, says, I don't want to sell, because they're obligated by that contract. They're bound by it. Sean, go ahead.
If that were to happen, and it sounds like that's where you are, Dennis, did I hear you say you're under contract?
Correct.
Okay, so if that were to happen, I would advise both of the clients to turn away from me and turn back to their divorce attorneys, or give you the ability to talk to their attorneys, because their divorce attorneys may be able to more fully explain to them. You can explain the real estate ramifications. They might go deeper in explaining, besides the real estate ramifications, the potential ramification from the other spouse in this thing that could, it could go deeper than that. You could lose the sale, and then that might impact the other person's life. So yeah, if that starts, I would try to be the sounding board, but then typically just say, go, each of you need to go speak to your respective attorneys in this divorce and get guidance on this, because you're making a less than informed decision.
And I need, Sean.
Mhm.
I had this situation, actually, when I was not in the business very long. I had the buyer and we were under contract, and the settlement was kind of a delayed settlement. So it was several months. I don't remember all the details, but in the course of that time, the husband decided he didn't want to sell the house. They were getting divorced, and 4 months ago, which you don't see this much anymore, but 4 months ago, everything was fine. So my buyers actually ended up having to go and sit with an attorney, and the attorney wrote a letter to the people and basically just kind of scared them out of it. But they had to go and hire an attorney. But that was part of the problem. There was, it wasn't a quick settlement. It was several months that went by, and things went south in that time.
They had time to think about it and formulate a plan of torment. Yeah, it's best. We can try and keep things moving smoothly, but when people get to that level of denial, frustration, whatever, turn them back to their attorneys.
And you're absolutely right. That's when attorneys come into play. We're not attorneys, and that's when you just as Sean had said, you instruct both of them to go back to their divorce attorneys, and maybe they can bring them back together again, or whatever it might be. But there are legal issues there because you are in a binding contract.
I still haven't seen it. I can't do both these things.
Anybody else have anything? No?
Good luck, Dennis.
Yeah, real quiet. Well, I guess with that being said, I want to thank everybody for joining us today. I hope you got something out of this. And as we always try to do, we try to educate everybody. But I thank everybody for attending. We had a good group here today. Okay?
Thanks, George. Thanks,
Thank you.
Sean.
Nice.
Take care, guys.
Bye-bye.
Bye, everybody. Thank you.
Bye.
Bye.